All right, continuing on here on the Civil Liberties chapter, slide number 53. Hopefully we can get through this relatively quickly. I'm not going to belabor a lot of this, but let's get in there, okay? The rights of persons accused of crimes. And the main right that a person has accused of crime is something called due process, okay? It's all the legal protections that you have to preserve your rights, okay? And included with that is something called procedural due process, okay? It's procedures authorities must follow before a person can lawfully be punished for an offense, okay? So it deals with all of the procedural safeguards, okay? Your right to counsel, Miranda rights, things of that nature, okay? So one of the first elements they talk about here, slide 54, is the suspicion phase, okay? If they think you might be committing a crime, the police may search and seize, property or something of that of yours, but they must follow the due process, okay? So the Fourth Amendment says the right of the people to be secure in their persons, houses, papers, effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by an oath or an affirmation, and particularly describing the place to be searched and the persons or things to be seized, okay? So again, the police cannot search your house unless there's a probable cause, and if you got a probable cause, you got to take it to a judge who has to sign something, some oath of affirmation, so that creates a warrant, and along with that, you have to say exactly where they want to search and where they want to seize and which person they're going to look at, okay? So in other words, it's got to be very specific because they're trying to prevent the police from just randomly coming in and randomly finding different things against you, okay? So again, it's a lot of protections for you, and unless you think perhaps that this is this is an imperfect system, and of course no system's perfect. Again, think secret police of the Russians. Think the Gestapo of the Germans, right? The Nazis. There was no Fourth Amendment protection for anybody in Germany or anybody in Russia back then, okay? So our system is vastly superior to a lot of other systems, okay? If you go to slide 55, it's not a blanket protection against searches and seizures. People that are caught committing a crime can be searched for weapons. It does provide protection against speculative and arbitrary police protection. The police must convince the judge of sufficient evidence of probable cause. The Supreme Court has lowered the standard police must meet to lawfully search a person. So the threshold is not as high as it used to be, okay? 56, slide 56, the arrest phase, protection against self-incrimination. Okay, Miranda versus Arizona in 1966. At the time of arrest, police cannot legally interrogate you until the suspect has been warned that your words can be used as evidence, right? And most of us are familiar with that one. In Dickerson versus United States, the court affirmed Miranda, calling it an established constitutional rule that Congress could not abolish by ordinary legislation. So in other words, it kind of placed Miranda up there with the Bill of Rights. Okay, that's very, very significant. In Missouri versus Siebert, police cannot question subjects before Mirandizing them, getting a confession, taking a break, Mirandizing them, getting a confession, as it undermines Miranda's warnings and violates the suspect's rights. So there can't be some sleight of hand by the police in Mirandizing you, okay? Slide 57, the exclusionary rule. What it does is it bars the use of evidence obtained in violation of the defendant's rights in circumstances, okay? If police know that illegally obtained evidence will be inadmissible in court, they're going to be less inclined to obtain it, okay? So in other words, if the police search your house, they've got a warrant, okay, it's signed by a judge, says where to search your house, okay? We're going into the living room because we suspect that that's where illegal drugs are. But then the police suddenly, they go into your basement and they find illegal drugs. The exclusionary rule prevents the police from submitting that evidence obtained in the basement because it was not, written there in that warrant, okay? So it protects you, okay? And so you can see some different cases on page 58 that address that, okay? In Weeks versus United States in 1914, the court held that the tendency of those who execute the criminal laws of the country to obtain convictions by means of unlawful searches and unenforced confessions should find no sanction in the judgment of the courts. In United States versus Leon in 1984, the court ruled that evidence discovered under a faulty warrant was admissible because the police acted in good faith. Okay, in other words, if it looks like the police were doing their best to write the warrant well and it wasn't perfect, okay, sometimes the courts will grant some latitude. There's also something called the good faith exception. Otherwise excludable evidence can be admitted in trial if police believed they were following proper procedures, okay? And then there's something called the inevitable discovery exception. Exclusion of physical evidence that would inevitably been discovered adds nothing to either the integrity or fairness of a criminal trial. So, you know, the warrant says that they can search your living room, okay? But on the way to the living room, in the kitchen, there's a sawed-off shotgun, okay? That's the inevitable discovery. In other words, you were most likely going to see it right there, okay? Is that, but it wasn't, you know, the warrant says the living room. If it's in plain sight and it's illegal, okay, and it's pretty obvious, that can be admitted in a trial, okay? Again, I'm not going to belabor that too much. If you go to the next slide, slide number 59, you know, cruel and unusual punishment. A couple of cases we want to talk about here. In Atkins versus Virginia and Panetti versus Quarterman, the court outlawed the death penalty for the mentally retarded on the grounds that it constitutes cruel and unusual punishment. Again, the logic of that is if that mentally impaired person does not have the mental wherewithal and they commit a crime, you can, and again, the principle in our legal system is you are morally responsible for the crimes you commit. But if you're mentally impaired, you cannot take moral responsibility. You don't even know what's going on, okay? Other case, Roper versus Simmons, the court invoked the 8th Amendment to ban the death penalty for cases involving juveniles and for crimes other than murder. Okay, if you actually go ahead and read that case, it was a pretty brutal case of how they brutalized this woman when these kids were juveniles. I think they're 17 years old. It was pretty patently obvious that they knew exactly what they were doing, but because they were tried when they were adults, but they committed the crime when they were juveniles, they were tried when they were adults, they got the death penalty, but because of you know, this decision, crimes like that committed when they were juveniles cannot, you know, you cannot get the death penalty because that's a violation of their 8th Amendment protection against cruel and unusual punishment, okay? In Trope v. Dulles is an interesting case in 1958. It was a case involving an American serviceman in North Africa who deserted his post during wartime, during World War II. And usually desertion of your post in World War II, usually you get the firing squad. Well, what the military did is they took away his citizenship. He lost his citizenship. And so he appealed his case and went to the Supreme Court. The Supreme Court said that removing a soldier's U.S. citizenship because of desertion in wartime is a violation of his 8th Amendment's prohibition against cruel and unusual punishment. And the logic the court used was very, very interesting. They said that the evolving standards of decency that mark the progress of a maturing society says that taking away your citizenship because of desertion in wartime is cruel and unusual punishment. Very interesting. Okay, very, very interesting. You know, it begs the question: are ethics fixed and permanent, true for all time, or do they evolve with society? Okay, and if they do evolve for society, you know, where do you find your reference point for what is good, for what is true, for what is beautiful, for what is right, for what is wrong? Okay, it's kind of you kind of got a foundation based on, you know, quicksand here, and yet it's an interesting logic. Okay, moving on. Slide 60. Okay, the rights of enemy combatants during war. Okay, traditionally, if you were a captured enemy combatant, you did not enjoy constitutional protection because you are not a U.S. citizen and you are fighting against the U.S. military. Again, think the increasing permissiveness of the Supreme Court on a wide range of issues, okay? In the case of the War on Terror, they began to give a lot of latitude to enemy combatants, Al-Qaeda terrorists fighting against U.S. soldiers. So here's some cases. So in Rasool versus Bush in 2004 and El Oda versus U.S. in 2004, the court held that Guantanamo Bay detainees had the right to challenge their detention in court. They reasoned that this naval base, though in Cuba, is on land leased to the United States and it's under the jurisdiction of U.S. courts. Okay, but again, they're enemy combatants. They're not even U.S. citizens. In fact, they're terrorists fighting against, the U.S. military. Hamdi versus Rumsfeld, the court ruled that one of the Gitmo detainees, who was a U.S. citizen, had the right to be heard in U.S. court. Interesting. A U.S. citizen fighting for our enemy has constitutional protection. Hamdan versus Rumsfeld in 2006, the court ruled that the tribunals, the military tribunals that basically held a lot of these enemy combatants as guilty of crimes against America, okay, they were unlawful because they did not provide even minimal protection of detainees' rights. Again, these are, in time of war, when an enemy combatant is tried for a crime, they are not tried in U.S. Article III courts, but rather they're tried in military tribunal courts, okay? And that has been traditional for American, military history ever since our founding. And so, again, in Hamdan versus Rumsfeld, they said that these military tribunals, the rulings of them were unlawful because the enemy combatants couldn't even see the evidence presented against them. Again, it begs the question, should Al-Qaeda get a lawyer? Should Al-Qaeda enjoy American constitutional protection? Very, very controversial cases. In Boumediene versus Bush in 2008, the court struck down a provision of an act of Congress which denied federal courts authority to hear appeals from prisoners who sought to appeal their detention. So the court struck down this provision of Congress. And so basically it gave enemy combatants constitutional protection, okay? Again, very controversial. And then finally, on slide number 61, the surveillance of suspected terrorists. After September 11th, the NSA began to surveil all kinds of telephone conversations, all kinds of emails, all kinds of internet transmission. And the Patriot Act lowered the standard of judicial approval for wiretapping when terrorist activity was at issue. What was found during the Obama administration was that the NSA was not just surveilling suspected terrorists, but they were using metadata of all of American citizens, okay, suspected terrorists or not, which begs the question, is that a violation of our Fourth Amendment's protection against illegal searches and seizures, okay? Very, very controversial. I, for one, have a big problem with it. I have no problem, with the NSA trying to protect us from terrorism. That's their job. That's their constitutional role. But the fact that the average American, knowing that every one of your emails, every one of your text messages and your communications are being surveilled by the NSA, is that problematic to you or not? What I have found as a teacher is the older generation, my generation or older, have big problems with it. The younger generation, the logic is this: hey, I'm doing nothing wrong, what's the big deal, okay? But that is operating on the assumption that the federal government are the good guys. What happens if in 10, 15, 20 years or something in the future, what if the federal government are not the good guys? What if it becomes an Orwellian Big Brother is watching you surveillance state, okay? And the federal government is meaning to do you harm or to coerce you or to control you in some way, shape, or form. Do you have a problem with it then? Maybe an assigned textbook for American national government should be that everyone should have to read George Orwell's 1984, okay? These are some of the issues that we're dealing with. One of the issues, that came up even within this COVID-19 crisis was that the government should have access to the location services of your cell phone to monitor where you go, to see if mandatory quarantine is taking place within a state and you left your house, the government could perhaps, nab you. Okay, are we comfortable with those types of things? As technology increases and government has access to it, You know, at what point do we lose our constitutional rights? Okay, these are some of the dilemmas and issues we're dealing with. So that's civil liberties. Again, this should hopefully help you with your discussion, post questions. And if you have any questions, please reach out to me. Okay, take care.